life of the beautiful Alexis Wilson. I stand here with family and friends. I'm just letting everyone know that we're going to continue to keep the memory alive. We're going to keep fighting. We're going to keep our hearts connected to the family so that we let them know that they have our full support. And no matter what, we're not going to stop until justice is done.
We will not stop.
Repeat after me. We will not stop.
We will not stop
until justice is done.
until justice is done.
We love you, Lexi.
We love you, Lexi.
Can we get a justice for Alexis Wilson?
Justice for Alexis Wilson.
Justice for
Alexis Wilson.
Justice for
Alexis Wilson.
We will not stop
Until justice is served.
Yes.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Guys, this is Super Mayor Tiffany A. here, the People's Mayor. So, you guys doing a lot of snitching.
And you know this. Blessings, Uncensored Enlightenment Talk family. You're here with your host, Grace Levi. I hope you guys get the notifications. We've been having issues with our notifications. Today, we have another part to the Alexis Wilson case, the saga. As you know, I have been doing a background investigation, trying to get as much information as possible related to what happened to Alexis Wilson. So today what we're going to do is divulge a little bit more information to the general. What I want to talk about before we get into who is as Hobson is we're going to talk about some of the things that's going on in the courts. It's very important. I want you to look at this case, and this case is remarkably similar to the Alexis Wilson case. It took place a couple of years ago. We're going to play it in the state of Texas, and this case made it all the way to the Supreme Court, okay? And it has changed a lot, so let's play this.
24 years. It happened in just seconds. 24-year-old Ashton Barnes pulled over on the side of this Texas highway. The rental car he was driving believed to have outstanding toll violations. Officer Roberto Felix Jr. appearing on the driver's side door, soon drawing his gun, prompting Barnes to take off. As Felix jumps on.
Doesn't this look remarkably familiar? And it was so crazy because when I was like, wow. So we're going to watch this. So we're going to get some details of how it went through state court and then made it to the Supreme Court and how they're pushing it back down with a new set of eyes.
Onto the car's running board and soon drawing his gun, prompting Barnes to take off. As Felix jumps onto the car's running board and fires, killing Barnes at the scene. Now, nearly a decade later, Barnes's mother, Janice Hughes, hoping the U.S. Supreme Court will change how courts treat these deadly police encounters nationwide.
I really honestly know that in my heart, Ashton did not deserve to die that day. Took a piece of me, an entire piece of me that I can never get back. I have to learn how to live with that missing piece.
A grand jury declined to indict Officer Felix on criminal charges, but Hughes brought a civil lawsuit that has faced an uphill battle. Lower courts finding Felix did not use excessive force. Their inquiry into his actions confined, focused only on the question of whether he reasonably believed he was in danger.
Now, I want you to listen to that because they're saying that the interpretation was refined and based on the reasonable belief that he was in danger, but it's pertaining to the exact time of the excessive force. So I want you to listen because that's what we're going to get into. And this is what has changed now. And this may set a lot of cases in a different direction now that we have this coming back down to Texas courts.
In the seconds before he shot Barnes, Felix saying this at the time.
I got to ask, why did you fire your weapon?
Well, when he started to drive off, I felt that I was going to get run over.
In arguments today, the justices wrestling with whether to say courts must broaden their inquiry.
So you already see his statement is a little inconsistent because he said he felt like he was going to get ran over. And obviously you can see right here, we're going to have to determine what a reasonable person would do. And that's what the courts is going to allow people to look at by basically opening up the preview of these situations to the full circumstances. So let me get you up to date to what's going on now. So mom didn't let go, even though the officer was not charged with excessive force. They had a civil matter. Civil matter was allegedly dismissed, and she would not leave it alone. And based on some of the arguments, and this is why you have to have a good lawyer in there, because certain arguments that are brought up, when it gets to the Supreme Court level, they have to look at it from a constitutional perspective. And this is what's helping this case. Let's play this real quick.
Later today, a landmark civil rights case is set to be argued before the Supreme Court. Justices will hear a Texas case that could make it easier or harder to hold police officers accountable for using excessive force. The case revolves around a deadly officer-involved shooting of a black man back in 2016. It was captured on a patrol car dash cam. A warning, the video we are about to play is disturbing.
It shows the moments before a Harris County deputy shot and killed 24-year-old Ashton Barnes after pulling him over during a routine traffic stop. Take a look. Barnes appears to drive away shortly after the deputy opened the door to his car. Central to the outcome of this case, exactly what happened during those seconds prior to his killing, and an evaluation of something that's called the moment of threat doctrine.
For more on this, let's bring in NBC News senior Supreme Court reporter Lawrence Hurley. Lawrence, thanks for joining us. So, it seems there's more to this story than what we're just able to see or hear in that dash cam video. Walk us through what allegedly happened in 2016 and tell us why Barnes was pulled over in the first place.
Right. So as you said, this started out as a routine traffic stop. The officer received information that the car that Barnes was driving had some outstanding toll violations because this incident took place on a toll road. So he pulled him over as a routine traffic stop.
Now, let's keep this in mind. The outstanding toll violations may be related to the fact that this is a rental car, too. There's more aspects to it. So I just wanted to add it because we're not going to go from different stories so we can kind of fill in the gaps like we usually do. But that's one of the aspects of this, that it was a rental car.
Started out kind of normal. They asked questions. And then it sort of started to go astray when the officer asked for driving license, and Barnes said he didn't have it on him, said it might be in the trunk of the car. And then things escalated when Barnes, according to the officer, then restarted the car and started to drive off. And then the officer jumped up on the car door sill as the car was moving, and then he fired his gun twice into Barnes and killed him at the scene. So that's what the facts are before the Supreme Court.
Yeah, and I guess the facts before the grand jury. At the time, the grand jury didn't find enough evidence to indict the deputy, Roberto Felix, with murder or any assault charges. The separate civil rights claim was dismissed based on what's called this moment of threat doctrine. Tell us what that is, and then why the Supreme Court is taking up this case now, nearly a decade later.
Right, so as we're looking back at that video, the key issue here is what does a court have to assess when they're deciding whether the officer used excessive force?
Now, this is what I want you to pay attention to, because this is what the judge will do, will give certain rules to the jurors of how they look at evidence. So this is some of the context they will give the jurors, and the jurors will have to look at that particular case at the moment that the excessive force happened versus the totality of the proceeding and the prior situation. Okay.
The moment of the threat doctrine, which has been applied in some courts, including the one that decided this case, says that only the moment when the officer actually decided to use force is the key moment to be assessed, and they decided there was no excessive force. But even some of the judges who decided this below said that although they were bound by that precedent, they actually thought that if you considered some of the previous moments going back a bit further, including the officer's decision to jump onto the sill of the car, instead of just de-escalating the situation and allowing Barnes to just drive off, because there was no evidence that he was armed.
And this is when you bring up the concept of what a reasonable person will do. Even with cops, it's like, what would a reasonable person do? Just jump on the car? It didn't even make any sense. And that's what we're going to look at in the Alexis Wilson situation, because now we have a clearer picture of what Officer Carlton did. We have a better idea of what injuries Officer Carlton did. But this was a great pretext to show you guys, because it's kind of like the same scenario where the first thing you'll look at is like, wow, the guy pulled off. Why would he do that? But in a court and as a juror, you have to look at the totality of the situation, or depending on what the judge say, as we just talked about, or all of the evidence, everything. So you really have to use your critical thinking. It's not just a one-hit wonder like what we do when we see something and be like, yeah, they were just totally wrong. That's why it have taken us so long to kind of rebrand and revamp the idea of what happened to Alexis, because of things like this can be received one way, but as I just said, what would a reasonable person do? So if what he did was unreasonable, pulling off, what the officer did was unreasonable, being a trained professional, paid public servant in that situation, which heightens his ethical line and duty of not harming people. You see what I'm saying? It got to be like, do you want to make it home? Is it worth it? And if I was a cop, like me and my healthcare professional, sometimes I just back up. I'd be like, nope, they don't want the help. Okay, nope, we're not about to do this, because as you see, when a car pull off, we can obviously see the license plate address that is linked to blah, 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 blah. And you'll probably most likely be able to use that information to get the driver with a little bit of investigation. And that's what they started to do in Jersey, because we had a lot of stolen cars and cops chasing after cars. And it's very dangerous to engage vehicles like this. So what he did wasn't looked at in the first few cases. Okay, now let's just listen to the rest of this, and then we're going to just get into what some of the Supreme Court judges said. Even Kavanaugh had something to say. Y'all know Kavanaugh. I know people wasn't happy when he got elected Supreme Court under the other Trump administration. I call him the drunken monk, but he had a little bit of sense in his ruling. Kinda. We're gonna go over it.
Armed or a danger to anyone, that should be taken into account as well. So the Supreme Court's going to be deciding whether the courts have to kind of consider all those preceding moments before the moment of the force is used. And if that is the case, then that would be a significant win for the plaintiffs.
I mentioned as we were coming to talk to you, Lawrence, it can make this easier or harder in certain cases. What do legal experts think that this impact could be on other cases when police officer misconduct is involved?
Yeah, I mean, one thing to note is that it's extremely difficult for any plaintiffs to ever win these cases, partly because of the defense called qualified immunity, which we've heard a lot about over recent years. But this case...
So you heard what he said. It's pretty hard for people to win this case. So that was one of the things I had to take in consideration. Cases like this, I had to take in consideration when I was told by Mama Carter that they settled and didn't take it to trial. You know, it was like, oh, take it to trial. But then you have these precedents that's already set up. And what are they going to look at? How they're going to evaluate the case? Qualified immunity, they're not there. But at the end of the day, you know what the blue cloak is.
Could remove at least one obstacle to people being allowed to bring these claims, which would allow the case to move forward, potentially lead to new precedent that says that officers in that situation should be on notice that they can't do that kind of conduct, and that they could be lose future civil rights lawsuits and not be protected by qualified immunity if they do it again in the future. So in that sense, it's quite significant.
Lawrence Hurley, thank you so much.
So
Because
it
the
is. So
suspect is
basically,
dead.
like he said, it's quite significant because allegedly doing this thing, I don't know if they're trying to be superheroes, um, is going to lead to more liabilities because the change in this court case. So you got a background, and basically it says, what does this mean for us? Local law enforcement agencies will need to update policy, train on materials, and incident review protocols to ensure that officers document and justify not only split-second decisions but also the broader context in which these decisions occur. Let me put this on the screen so you guys can see what I'm reading, and I'll share my link with you guys. Ugh, who is this? Who is this? JD Superba. This is a second level resource like a law firm. Okay, so it says this is what it means. Okay, so as I mentioned to you, basically the law enforcement will have to ensure that officers' documentation and justify not only split decisions, but also the broader context in which those decisions occur. Barnes versus Flex. So this is the new case, heightening the importance of comprehensive recording, keeping, and scenario-based training for Texas office, local law enforcement agency, as prior interactions and situational development can now be scrutinized in litigations over use of deadly force. And that's what we have today. And that's why I say all roads lead to court. No matter what administration we have in place, that's pretty basically what it leads to. That's how we fought a lot of the Jim Crow laws, not by out there protesting. There was, I'm going to put it in our community page. I forgot the gentleman's name, but it was one of our ancestors, and his name is not really known, but he did a lot of litigation in regards to Jim Crow laws, and that's how a lot of those laws were overturned through case law, not actually revoking the law because they're still on the books. It's case law. So if people discriminate or apply law in that manner, it's case law that was already fought that we can use. Does that make sense? All right. So what is this? What is this? The Supreme Court unanimously reject the very narrow approach to deadly force by the police. So it was a 9-0 that they rejected it. Let's just get that on because I really want you guys to understand the importance of this case. And when many people face these excessive force cases, they're going to be able to use this. They're going to be able to use this. All right. After we get to this, hold on. Matter of fact, let's just get into the case, and we don't have to get into another article. Let's get into the Supreme Court ruling, the opinion of the court. I'm not going to read the full document, but we have some of it. We have it for you. You know I'll be creeping. And if I'm going to reference it, we're going to have the facts. So this is the opinion of the court. The district court granted summary judgment to Felix. So that was the cop. They granted him summary judgment. The court explained that to prevail on her claim, Ms. Barnes, this is the mother, needed to show that Felix's use of force was objectively unreasonable. So in that particular second, with him being on the car, it was reasonable. And that's what I was saying when it came to Officer Carlton. With him being in the car, they will find it reasonable for what he did. But if they consider how he got in the car and the circumstances before that, it will be deemed unreasonable. That's why we're going to go over it. In the usual evidence focused case, the court noted the inquiry into reasonableness would involve considering a variety of circumstances. But when an officer had used deadly force, the court continued. The Fifth Circuit had developed a much narrower approach. Okay, so this was through case law, they developed this narrower approach. Then a court could ask only about the situation existing at the moment of the threat that sparked the fatal shooting. Okay, the district court identified that moment as the 2 seconds before Felix fired his first shot. Okay, and when he was standing on the door rails of a moving vehicle. Now, this is some of the situation that people not taking consideration. At that moment, the court found an officer could reasonably think himself at risk of serious harm. So, and under the Fifth Circuit ruling, that fact also concluded the analysis. The court explained that it could not, it could not consider what had transpired up until then. Those only those last 2 seconds, including Felix's decision to jump on to the seal. More robust explanation might have aided in the assessing of the reasonableness of the shooting. So if they had more of the situation and a more robust examination, they probably would have been like, okay, this could have been avoided. And it really could, because all he had to do was just step the hell back and let the car. And that was the same thing that Officer Carlton could have done. But we're going to show you Officer Carlton did something just like this particular officer. So does this make sense? Now, I think this goes in a little bit of what Kavanaugh say. So when they got to the Supreme Court, they actually had to side with the lower courts because of the prior decision. But it was saying the circuits proceeded to, okay, it says, although a more robust examination might have been aided in the assessing of reasonableness of the shooting, the court was duty bound. So they were saying this court was duty bound by the circuit proceedings, like the case law before. That's why we got to take them to court and create precedents and fight in a manner that is, how can I say, creative. To open some doors. Yeah, that's why we do this. That's why we do this. Like find a back door, how Chief Price used to try to do. Now, the Court of Appeals affirmed that Felix, they affirmed the lower court's decision, explaining that it too was bound by the circuit's moment of threat document. So they said they was bound. Under that rule, the panel agreed the inquiry is confined to whether the officer was in danger at the moment of the threat that resulted in his or her use of deadly force. Any prior events leading up to the shooting, including actions of the officers took, were simply not relevant. Okay, and there, as the district court found, the present moment of the threat was the 2 seconds. So they had sided with him. In a concurrent opinion, Judge Hagenboff, who also authored a panel opinion, expressed concern with the Fifth Circuit moment of threat. So she expressed concern because they all can write the judge's opinion, and you can use the judge's opinion as well in court to fight cases, not just case law, judge's opinion, the law, things like that. This is what you use to fight. So in this judge's opinion, now this person is acknowledging the moment of threat doctrine. He thought that the rule inconsistent with the court derives to assess the reasonableness of the officer use of force, including deadly force, by looking to the totality of the circumstances. Under the totality approach, Judge Hagenbotham wrote a court could consider not just the present millisecond when an officer deploys force, but everything that has transpired up until that time. And when the wider focus, Judge Hammondbuff would have found that Felix shooting of Barnes was unreasonable. Okay, so it says, in resolving the Fourth Amendment excessive force claim, courts may apply the moment of threat rule just described. We hold that may not because they may not, because that rule constricts the proper inquiry into the totality of the circumstances. So I could go on and on and on, but basically this judge's opinion has opened up the doors for us to possibly get some justice, because now your whole story will be able to be told. Isn't that wild? That you thought you could just go to court and just blah, 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 tell a whole story in time order, tell a whole story in time order, and they be like, nope, not relevant. Nope, strike that. No, that's why I watch court cases, because at first I used to get confused, like, why are they striking that? That's what happened. But it's other court cases, judge's opinion, president laws that restricts the use of certain things in court. And that pertains to evidence and other stuff like that. I just want to say thank you so much for being here with me, being here and getting into this content, expanding your mind. The case that we showed you may can help you or help someone else, as well as it helped us get a comprehensive understanding of how the court implements law. You know, sometimes we think that we go there and just tell everything, and we can't. So now it makes sense when we look at these court cases. Why the judge won't let this evidence in? Why is this hearsay? Why is this? Why is that? So with that being said, I think we shared a lot today. We try to share from an unbiased perspective. Again, shout out to S. Hobson. I would say you tried, but you could have did better, but you should not have lied. Okay. And you know what we're doing here each and every day. Here we go.
Guys, this is Super Mayor Tiffany A. Hilliard, the people's mayor. So, you guys doing a lot of snitching, and y'all went and got.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be.
Public comment, and she'll just put her head down and she won't listen to anything. She won't acknowledge anything. You know, I've seen mothers of murdered children and people who've lost family members in Dalton. She'll put her head down. And
I'm Cara Wilson. I'm the mother of Alexis Wilson, killed by Dalton, Illinois police. At the time that my daughter was killed, Tiffany stood in front of a microphone much like this and said that she stood with the cops and they did do the right thing by killing my 19-year-old child. Not only did she not take those words back, she didn't offer her condolences. She's never said anything. The first thing she did was hire this group of security guards to surround her and PR. So the real reason Tiffany has security is hiding from accountability about what she said about Alexis Wilson when she was killed. Now, if you watch the coverage of this murder, these officers violated her rights, reached in her car, jumped in her car, and put 7 bullets in my child, 2 in her head and 5 down her side. And the next day, you guys tried to spin it like she did something. Watch the video. She did nothing to deserve this. And again, last time they brought up Alexis, she's doing what she does now. Look this way, look that way, every way, but at the person talking. You don't give a damn, and you never did, and you never acted like it. She called out a whole press conference to call my daughter a criminal, and Homewood Flossmoor graduate with no criminal record. But Tiffany, you have one.
Leader, they want to hear from the mayor. If y'all ain't learned that yet, the mayor, not the trustees that don't do nothing, that only run their mouth. Y'all don't do no work, no work. Y'all forget I am the leader.